assume there's a Trump versus Democrat and Trump wins by some quote-unquote miracle. And I'm not saying I'm in favor of the miracle, but I think if he won, it would be by a miracle, because all stops will be out from the media and elsewhere to, sabotage his campaign. But assume he wins, and then assume that he's convicted in New York, in D.C., in Florida, any one of those three, or maybe permutations and combinations. Now he's the president of the United States, and he's been convicted of a felony.
This is Kaiser Johnson with Liberty and Finance, and these are the Miles Franklin Weekly Specials for March 11th through March 18th, 2024, while supplies last. First, we feature 90% junk silver mixed dimes and quarters at just $1.99 over spot. We also have AU pre-1933 Gold Liberty at $65 over a 1-ounce spot. And finally, we're offering our choice 1-ounce palladium bars at just $119 over spot. To order our specials or any of the many other options we have available, call us at 1-888-81-LIBERTY. That's 1-888-815-4237. We're available after hours and on weekends, and we look forward to speaking with you. Welcome back to Liberty and Finance. We are privileged to have this distinguished returning guest. Dr. Edwin Vieira is a constitutional attorney who has argued cases up to and including the United States Supreme Court. He's written a book, The Pieces of Eight, about sound money and the roots of its roots in our Constitution. He is expert on the constitutional roots of the Second Amendment in the militias of the states before the United States of America was even formed. He's been with us several times talking about government overreach in the breach of privacy, breach of private property rights, etc. Dr. Vieira, thank you for coming back on Liberty and Finance. Today is Monday, March 4th, 2024.
Thank you for having me again.
We wanted to talk with you today about two topics. We'll take these in turn. The first one is this barrage of legal challenges that have been aimed at former President Donald Trump that seem to be more or less coincidentally happening right before the election year here and perhaps interfering with the election. There's some question on the parts of many analysts whether these are in fact designed in coming together as a warfare or lawfare, as you might call it, to derail his candidacy. Could you talk to us about what we're learning about that and the most recent actions by the Supreme Court and the progress on that and the direction it's heading?
Well, the direction it's heading is down to oblivion, given that the Supreme Court has just released an opinion in the Trump versus Anderson case. Just came out. People can find it now, I'm sure, on the internet, because I have a copy of the opinion sitting right in front of me that I printed off, dated the 4th of March. So it just came out today. And pretty much it goes into what I would call somewhat convoluted analysis of state versus federal authority as filtered through Sections 3 and 5 of the 14th Amendment, which relate to the disqualification of anyone in office or candidate for office if that person has engaged in insurrection against the United States. Now, what I found interesting about this opinion, besides the fact that actually there is a split, there's the per curiam opinion, which just sets aside this Colorado action, and actually the concurring opinions, one by Amy Conant Bryant and the other by the liberal ladies on the court, lady justices on the court. They all agreed. It's a 9-0 decision. So there's no dissent with respect to what Colorado, and I take it Maine and Illinois, some of these other states have already done either through courts or through administrative processes. But the decision, the per curiam decision, which is the actual decision of the court, really goes off on a somewhat convoluted analysis of the interaction of Sections 3 and 5. And I thought this long ago. I wrote an article on it on newswithviews.com, and I still think the point I'm making is the basically correct one. Insurrection has always been a felonious or criminal offense. And what was done in Colorado, of course, was a civil proceeding. What was done in Maine, and then more recently, I think it's Illinois, were administrative proceedings. So Colorado had some kind of civil trial, and the other two had simply administrative determinations, so there was no trial at all. So you run directly into the question of, well, how can you apply a provision of the Constitution talking about insurrection with respect to a particular individual, a named individual, and not ask the question, well, when has this person ever been convicted of insurrection? And to be convicted of insurrection, if you go through all of the provisions in the U.S. Constitution that are protections for people who are charged with crimes and people who are tried for various crimes, you'll see that, well, you can't make a determination in a civil case. You can't make a determination in an administrative law proceeding. It's not enough for some civil judge or civil jury or administrator to say, well, I listened to Rachel Maddow and Joy Reid and Whoopi Goldberg, and they all told me that Donald Trump had been engaged in insurrection, and therefore I can now apply the Section 3 of the of the 14th Amendment, this federal law, to him in my particular state, administratively or in a civil case, and bar him from the ballot, or I suppose even if he were written in, bar him from receiving those votes to be cast for him in that state election. And the Supreme Court doesn't seem to be paying much attention to that obvious point, that insurrection has to be determined independently of this next step of disqualification. Right? It has to be part of the determination or part of the action that is taken. Right? Someone who, because as it says, someone who has previously taken an oath, that we're talking about the person to be disqualified, shall have engaged in insurrection or rebellion against the same. So those are the two things that have to be determined. The person had taken an oath as a public official and then engaged in insurrection against the United States. Well, how is that determined? And insurrection is a crime, so it would have to be determined through a criminal procedure, so someone would have the benefit of beyond a reasonable doubt standard of guilt, right? Well, that's the answer to the question. Has that happened to Trump? Let's take Trump as he's the petitioner in this case. Has this happened to Trump? And the answer is, of course, well, no. A lot of people, loosely have been equating things he said or did on the 6th of January with somehow involvement in being engaged in insurrection. And one of the things one always has to look at is, of course, what he was doing was speech. He wasn't walking into the Capitol or leading people towards the Capitol and taking various physical acts. There are various Supreme Court opinions which have dealt with the interaction of free speech and things like insurrection, sedition, criminal syndicalism, the different words that are used for these kinds of acts. Advocacy of overthrowing the government. Communist Party for a long time was being chased by various statutes, state and federal, because of its advocacy of the overthrow of our form of government and the substitution of a Marxist-Leninist, Stalinist, whatever, communist form of government. So the Supreme Court had ruled on several occasions. Brandenburg versus Ohio was one. The Scales versus United States, Noto versus United States. A bunch of these cases out there at either the state level or the federal level would say, well, the mere advocacy, even a violent overthrow of the government, is not sufficient for a person to be prosecuted under any of these theories, because that's protected by the First Amendment. Now, if that advocacy leads to imminent lawless action, then it's another situation, but that's something that has to be tested in a court case involving a First Amendment defense. All right? So you have first, the prosecutor has to be able to establish some basic structure of facts to claim that the defendant is engaged in or was engaged in insurrection. And then, of course, the defendant can raise, among the other defenses that he might have, he could raise the First Amendment defense that he was engaged solely in abstract advocacy. He wasn't engaged in promoting imminent violent unlawful action, and therefore, notwithstanding he did all these other things, potentially he would have to have a not guilty verdict. So you would think that would be the center of this whole question, because, of course, the January 6th event occurred where? In the District of Columbia. And no other state would have jurisdiction to prosecute, let's say, Mr. Trump, who's the subject matter of this whole brouhaha, for an insurrection criminal act, supposedly alleged criminal act, that occurred in the District of Columbia. So it would seem to me that would be the end of it. The man has not been arrested, arraigned, indicted by a grand jury, tried on the basis of beyond a reasonable doubt standard of guilt, and had all of his various post-trial motions and appeals denied. None of that happened. And it would have had to happen in the District of Columbia unless Congress had some statute that allowed actions of that kind in the District of Columbia to be tried somewhere else. So that it would seem to me that would be the simple answer to this question. We don't even get to the 14th Amendment intricacies until somebody establishes that the individual we're talking about, in this case Trump, was engaged in, has been convicted of insurrection. So this is an interesting essay, I suppose you could put it, in some constitutional intricacies of interpretation of the 14th Amendment, rightly or wrongly. So I won't go into the details of those. You'll let the legal people will be talking about this for the next 6 months, obviously, on the internet. But I think it misses the point that insurrection is a criminal offense, and the insurrection that you have to be talking about in a 14th Amendment context, because that's a United States constitutional provision, has to be a unified definition of insurrection. It has to be a unified definition of engaged in, and the whole business has to be in some way overseen by Bill of Rights considerations, First Amendment, Fifth Amendment, Sixth Amendment. Let's take those three. Right? Not to mention the provisions of the U.S. Constitution in Article 3 dealing with the right to jury trial and so forth and so on. And that's just not covered. So I thought to myself, this looks like they were very interested in getting into the swamp, if you will, the intellectual swamp of constitutional interpretation when they really didn't need to. Because insurrection could be defined a whole bunch of different ways, I suppose. Engaged in could be defined a whole bunch of different ways by various states. And how could that control the determination under the federal Constitution? State interpretations or state statutes don't control the meaning of terms under the federal Constitution. And you could have potentially 50 of them, 50 different interpretations of insurrection, some stricter than others. You could have 50 different interpretations of engaged in. What do you have to do to be engaged in an insurrection? Well, a lot of people are saying Trump was standing around talking to people, and therefore he was engaged in an insurrection if what happened thereafter was an insurrection. Well, that's a debatable question right there. How close did he have to be to the involvement of those people who broke windows in the Capitol or did whatever they did that could be considered riotous behavior? I don't think any of it was insurrection. That's all nonsense. But certainly riotous behavior, illegal in that sense. And how close was he to that such that he could have been engaged in it? Well, these are all definitional problems. And when you come to the federal Constitution, they are definitional problems of federal law. The states don't make those determinations. The federal Congress, federal judiciary, perhaps, or the Constitution itself. I mean, look at the words of the Constitution. You can tell what they mean. Those are the controlling definitions. But what I think you'll see happening now are, of course, people attacking this. This will be the poster child for anti-Supreme Court rhetoric. And there are a lot of people already coming out and attacking the Supreme Court as being partisan and things have to be changed. Someone just the other day, the Supreme Court's partisan, it's all a bunch of Republicans and in control. And so something has to be done to change that. Well, what are you going to change that? Well, you change the composition of the court as one justice leaves, you put another justice on. But that's not what these people are talking about. I think they're talking about things along the line of what Franklin Roosevelt attempted to do in 1937, the court packing scheme, as it's called. He proposed that the number of justices be increased significantly. And of course, then he would have had the opportunity to appoint these new justices. And that would have changed the, let's say, the ideological composition of the court, because that's the way the Democrats were looking at it. It was all ideology, people against Roosevelt's New Deal. Well, there was a lot of people that were traditional constitutionalists, and Roosevelt didn't like that. And actually, some of them had ruled in favor of his New Deal proposal, so it was 6 of one, half a dozen of the other. But the point was, at that time, even the leaders of the Democratic Party, who were willing to go along with Roosevelt with respect to all sorts of legislation that was wild in the sense of its incompatibility with the Constitution, they were willing to go along with that, but they were not willing to go along with the court packing scheme, because they recognized that that would have some kind of fundamentally destabilizing effect. And I think that's what's true here. This thing may generate a fundamentally destabilizing effect, because although it's a 9-0 decision on the merits of this particular claim, you have the liberal lady justices, Sotomayor and Ketanji Brown, that group, and even to a certain extent, Sotomayor, Kagan, and Jackson. And you also had Justice Barrett writing a concurring opinion, but she's really saying that, well, we all agree on this. We may disagree on some things, but we all agree on the outcome of this case, and that is the message Americans should take home. So she's kind of calling for, peace on the legal front. And the other three are kind of raising questions along the lines of, well, maybe this decision, even though it's 9-0 on this, there still remain some areas that are in contention. And of course, we'll hear that from, Rachel Maddow and Joy Reid and, all the other talking heads in the media. They'll be playing on this for a long time. Well, basically on which I call it the illegitimacy, some kind of fundamental illegitimacy of the Supreme Court. But I leave that with you, because the short answer is that's gone now. They have a 9-0 decision that states, and obviously the administrative agencies, all these lower level official entities in the states, can do zero with respect to removing a federal official. It's interesting that the opinion says, well, we're not going to talk about that the states could remove state officials. All right. And that's where you get into the interesting situation, because as soon as that would happen, that there's some pro-Trump candidate running for governor or something, and a state attempts to remove that candidate. And then we get, because he was at January 6th, he was standing next to Trump, all right, or what, he was in the White House, something along that line, right? Not that he was breaking into the Capitol. Then we run into exactly the problem. We're back to the problem I mentioned earlier. Right? The man was not convicted. They're going to find this in administrative proceedings. Secretary of State's going to do it to him. Election Commission is going to do it to him. State civil trial is going to do it to him. He hasn't been convicted of insurrection. He hasn't been convicted of engaging in insurrection as a matter of federal law. But nevertheless, the stand. So they leave this open. This is one of the examples. The Supreme Court does this all the time. They open their mouths on things they shouldn't open their mouths about. They should talk just about what's in the particular case in front of them, and not raise these what ifs and buts and so forth and so on that may apply or may not apply, or may raise difficult questions in other scenarios than the one that's in front of them. So they raise this one. A state official, someone running for state office, the states might have some ability to enforce Section 3 of the 14th Amendment on their own. And thus we have the possibility that the same people that wanted to raise lawfare, as you would call it, against Trump, these basically illegitimate litigational tactics, would use that now, turn and use that against various state candidates or state officers, because this particular provision, Section 3 of the 14th Amendment, is not limited to someone who's running for office. It could be someone who's in office, right? Who maybe had something to do with Trump on January 6th, or was there standing around on the Capitol grounds on January 6th, right? Or was talking on Zoom to someone who was engaged in some activity on January 6th. And so you can imagine that as kind of an interesting fallback position. Now they can go after punishing the friends of Trump, the allies of Trump. They can't get him particularly, but they can go after people at the state level. And the Supreme Court seems to have opened that door open. They've opened the door. They haven't said what the answer is, because that, of course, depends upon what comes up percolating from some kind of state litigational process. And that's why I was a little disappointed with this, because it seemed to me they needed to say, wait a minute, insurrection is a very serious charge, and it has to be made out in the criminal context where at least the person that's being charged gets the benefit of the beyond the reasonable doubt standard of guilt. And then that has to be a definition of insurrection, because the judge will tell the jury, these are the elements of insurrection. The man has to do this, 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 and this, and then you can find him guilty of insurrection. And if not, then he's innocent. Right? Not guilty. No one's ever innocent. Not guilty. And that would have to be a federal standard. And then, of course, there's all the evidentiary rules and so forth that might apply as well. So, yes, this solves one problem with respect to Trump, and unfortunately it opens up the proverbial can of worms in other ways. So it doesn't really close the door. And there are those three lady justices, the liberal lady justices, who are pointing at that open door. They have to agree this case, 9-0, they have to agree this case is no good. But they're leaving open the possibility that there could be some other cases fomented, and obviously fomented by whom? Fomented by the same people who are going after Trump. They're certainly not going after Biden or somebody else. They'll be going after Trump and anyone who's associated with him if they can make that out. And of course, we have the whole thing going on with these cases. Otherwise, it will eventually get to the Supreme Court. The hush money case in New York, which is that's a trumped up case. They're trying to enforce a federal statute in New York, under circumstances in which the Federal Election Commission already looked at the issues involved and said, no, it's not a violation. Of course, you have a criminal case going on in D.C., and before the Supreme Court now is the question of presidential immunity immunity for something that the president did while in office that would keep him from being prosecuted once he's out of office, because almost everyone agrees that you can't prosecute a president when he's within office. And that'll be interesting to see how that one comes out, because on the face of it, one would say it would depend upon what the alleged crime was. I mean, there are a lot of situations where the president has definite discretion to take certain kinds of actions, and it has never been the theory of the courts that discretion can be investigated, and the courts can say, well, it should have been done a different way. So if someone tries to make out some sort of criminal case based on the exercise of discretion, the answer would have to be, well, no, the courts can't look into this at all, because if it's a discretionary act, and it's what the courts call a political issue, and it can't be made into a criminal charge. But then on the other hand, the question becomes, well, maybe it's not entirely discretion. Maybe it was a duty he had to perform, or a duty not to do something, in which case you'd say, well, he may have immunity while he's president, but as long as the statute of limitations hasn't run, and how do you calculate that? Calculate that from the moment he leaves office, or do you calculate that from the moment the act occurs? Who knows? All right. But in any event, once he's out of office, then he can be prosecuted for this act, which is not was not discretionary. It's no longer a political question. It now becomes a judicial question. Okay. So we'll see how that one comes out. And then, of course, you have the complicated one going on in Days of Our Lives. It's like a soap opera going on in Georgia, right, with the prosecutor there and the special prosecutor, and everything went on or didn't go on, or who knows, whatever, who's going to be disqualified, what a disqualification would mean in terms of the continuation of that case. And then, of course, you think about the people who took pleas in that case simply to avoid the cost of going forward with the litigation, which is always a consideration. What will happen to them? Will they be able to come in and say, oh, we want these pleas, we want to rescind these pleas, we want to take these pleas back, nullify these pleas, because the whole proceeding was invalid from the beginning? Who knows what a rat's nest that'll be. And then there's the Florida case with the classified documents, which Trump had in Mar-a-Lago, in comparison to everything that has come out about Mr. Biden's obvious misuse of classified documents. He never had a position as a president to declassify documents. So all the documents that he had that are the subject of this inquiry, he shouldn't have had. He had no authority to have them. So he's in a theoretically a pretty bad case. That's a very interesting case, too. See how twisted all this is. The special prosecutor said, well, yes, he did all of this. It's a clear violation of the classified records provisions. He had the documents here, there, and everywhere. They were in the back of his garage next to the Corvette, whatever, all right? And he had no authority to have them because he was only either a senator or a vice president, and he was not in a position to declassify these documents. So as soon as he took them out of wherever, the Capitol building, or he took them out of the White House, there was a violation right there, and it's been a violation ever since. So what does the prosecutor say? Well, he's an old man, and he's forgetful, and therefore we don't think that a jury would convict him, and so we don't recommend, the prosecutor's office, we don't recommend prosecution. That's a very confusing statement because that's not the way the law works. The acts that Biden was alleged to have engaged in that constitute the violation of the government records statutes were done years ago. They weren't done on the same day that he had a deposition with this special prosecutor at which he made statements that showed he was forgetful of this. He didn't remember when one of his sons died, so on and so on. Right? And said that this showed that the man was what? They didn't really give a clinical medical evaluation of him. And the intent of the defendant is determined as of the time the alleged crime is committed. And maybe later, because he never returned the documents. He never made an attempt to return the documents until the Trump thing blew up. The Mar-a-Lago documents case blew up. And then it became apparent that he had a problem. Maybe his lawyers told him he had a problem. And then he started talking about documents that he had and how he was going to return them, whatever. And nobody ever said that in that period of time, going back to when he was a senator and was taking documents, that he was suffering from Alzheimer's disease or diminished mental capacity or anything else. So he certainly could be tried on events that occurred at that point in time, and his present capacity would not be relevant to the proof of the violations. Secondly, how would his present mental capacity even come up in a trial today? Well, the government wouldn't raise it. The prosecutors wouldn't raise it. It would have to be his defense attorneys. And his defense attorneys would probably not want to raise that because either they have to put him on the stand or they have to bring in experts to say, medical experts who say, we evaluated this man and he has, diminished mental capacity, so he can't even stand trial. Now that's fine because you have cases where somebody committed a crime in the past and then for whatever reason he ends up with diminished mental capacity. He goes insane. Maybe he becomes psychotic. Maybe he gets Alzheimer's. Maybe he has some other deficiency, medical deficiency that causes him brain cancer, whatever. And so at the time of trial, he's not capable of being a competent defendant. He can't defend himself because he can't get on the stand. He can't aid his lawyers in defending him because he can't tell them or engage in conversation with them that would be useful to developing a defense. So then they say as well, at this point in time, we can't try him because he's, in some sense, mentally deficient. Just as we could say way in the past, if the medical experts could say, well, when he took these documents, he was mentally deficient. At that point, you'd say, well, he's not guilty by reason of mental impairment, insanity, is the way to put it, not guilty by reason of insanity, right? At that time. Or now, it's, well, he can't stand trial now because he's incapable of functioning as a defendant. He can't help himself and he can't help his lawyers. That doesn't mean he wasn't guilty in the past. It's just he can't have a trial now. But if you say the latter, that he can't have a trial now because he is so impaired that he can't help his lawyers and he can't help himself. He can't go on the stand and he can't aid his lawyers in making appropriate defenses, seeking out other witnesses, whatever. Then how is he competent to be president of the United States? One would think that would be the end of it. A person who is that incompetent that he can't testify or aid his attorneys in developing a case clearly cannot make the decisions that are necessary for functioning of the office of president. So that would immediately bring in Amendment 25, 25th Amendment, which deals with the incapacity of a person in that office and then what has to be done. Now, of course, that was, in the sense that thing was rigged from the beginning to make it almost impossible to remove a president, make it very difficult, right? Because it requires a vice president majority of the officers of the executive department, such other bodies, as Congress might set up, to transmit to the president of the Senate and Speaker of the House of Representatives declarations that the president's unable to discharge the powers and duties of his office, and then the whole thing has to be decided by Congress. Well, you imagine that's a real rat's nest. And that's obviously not going to happen with Mr. Biden. Kamala Harris and the heads of the various departments are not going to make those declarations. And obviously the Senate is not going to go along with removal, even if the House wanted to. So it's basically a hopeless situation. But what it accomplished was that Biden is not going to be indicted for these classified records allegations against him. And that's the trick. All right? The excuse that's given is not a valid excuse. Criminally speaking, the fact that he now may not be entirely capable of remembering what he did is not a defense to what he did, because that was not his problem when he did it. Right? They're not saying that he had this mental state way back when he was a senator, way back when he was vice president, and that's the reason that somehow those documents ended up in his garage or in the Penn State Biden Center or wherever they were, improperly, allegedly improperly. That's not the defense. The defense is now he can't function because he can't remember things. Well, he can't remember things that would help him in his defense back in, when he was a senator or when he was vice president. Okay, that's fine. But it's one or the other. Either he's competent to stand trial, or he isn't. But that has nothing to do with then. Or he was incompetent then, which nobody is saying is true. And in any event, the jury has nothing to do with this in a trial. The fact that the man now he could be sitting there saying nothing in front of the jury. Or maybe his attorneys would put him up on the stand and they'd ask him some questions. He'd be cross-examined. And I don't remember, I don't remember this, I don't remember that. Well, the jury might disbelieve it. But maybe the jury has sympathy for him that he can't remember. That has nothing to do with guilt or innocence. Right? The sympathy of the jury for the defendant is something that we hope never comes into play as to whether the person is guilty or innocent. Guilt or innocence is a different question, not whether we're sympathetic to the fellow or not. Right? The sympathy question arises when the man is convicted and now he's in front of the judge for sentencing. And the judge says, well, you did this way back then, but now you're semi-vegetable or whatever. I'm not going to send you to prison for the length of time that a normal person would serve. You're convicted. I'm going to give you 15 years or whatever it is, sentence suspended, and 6 months of home confinement, and 6 months of probation, and I'm going to give you a fine of $50,000 or something to contribute to some kind of charity for the mentally ill. Oh, okay. You say, well, the judge is exercising some modicum of mercy, sympathy, out of sympathy for this defendant because the man is now seriously impaired. So we're not going to put him in a maximum security prison or whatever, or even the medical facility, a federal medical facility, prison facility. But that's a different question. So that whole business is another mess that we have here. They're mixing apples and oranges, and the result of it is, well, Biden is not going to be indicted. Well, what has that done now? Just as this Trump versus Anderson case is probably going to continue to raise questions of the illegitimacy of the Supreme Court because the anti-Trumpers and the pro-Trumpers will be fighting each other in the media. What about this thing with Biden and the classified documents versus Mar-a-Lago with the classified documents? Is that now going to raise further questions about the fundamental skewing of the justice system within the Department of Justice? Right? Even when the special prosecutor finds that there are violations, he lets the guy off. Well, that certainly didn't happen with Trump. And so there'll be demands to say, well, this is selective prosecution against Trump. Obviously, that's what they'll say, obviously selective prosecution. Of course, they're going to claim against Trump that he was obstructing justice because whatever. And that's another one of these lawfare things because, I don't know, obstruct justice when your lawyers are negotiating with the federal prosecutors or whoever it was, maybe it was the records people, about how to deal with these records. I mean, that goes on all the time, even in criminal cases, where the defendant's attorneys are negotiating with the prosecutors and maybe making it a little tough for the prosecutors because they're pointing out that they have defenses they're going to raise and so forth and so on. And so the prosecutors have to, as the expression goes, cut some slack, right? Well, who calls that obstruction of justice? I mean, that's typical way defense attorneys work. They're trying to get the best deal they can for the client if they feel they can't necessarily get him acquitted. So we go into that. There's another one. Is that obstruction of justice charge? And the related charges, another example of the twisting of the system. So they've created a mess. That's the short answer here. They're delegitimizing the Supreme Court. They have already delegitimized this whole process in New York and in Georgia. I don't think there's a person in the country that looks at those things, even if he wants Trump to be convicted, looks at those things and say, well, those are just run-of-the-mill correct prosecutions. And then, of course, you have what's going to come up in D.C. and in Florida, the Jack Smith prosecutions. He's the prosecutor with his kind of novel ideas as to what constitutes criminal behavior. I mean, the man does have a bad personal record of being overturned in some of these criminal cases he's brought. But in any event, so there's that. We'll see how those two turn out. And then the interesting thing becomes, what if one of those results in a criminal conviction before the election? Because I guess we assume Trump, just assume for purposes of this argument, that Trump is the nominee. I don't know who the Democrats will nominate. I don't think it's going to be Biden. Because it seems that his condition, the poor fellow, I feel sorry for him. If you had someone in your family that has that condition, as I have, you know that it's not a good scene, in many, many ways. And so I feel sorry for the man. his friends and his wife and so forth should be advising him to step aside gracefully, but I don't think he will, and so they're going to put somebody else in. But the point is, assume there's a Trump versus Democrat, and Trump wins by some quote unquote miracle, right? And I'm not necessarily saying I'm in favor of the miracle, but I think if he won, it would be by a miracle, because all stops will be out from the media and elsewhere to sabotage his campaign. But assume he wins, and then assume that he's convicted in New York, in D.C., in Florida, any one of those three, or maybe permutations and combinations. Now he's the president of the United States, and he's been convicted of a felony. Well, there are all sorts of disabilities that attach to people who have been convicted of felonies. And I say that with a certain amount of reservation, because, the way they define felonies today is always unconstitutional. And I mean always unconstitutional. It's usually it's a sentence of 1 year or more, and in some cases $1,000 fine or whatever. They add certain things on. But if you look at the actual Constitution, the word felony does appear. Here's Article 1, Section 8, Clause, 10, to define and punish piracies and felonies committed on the high seas and offenses against the law of nations. Well, there's a constitutional term, felonies. What were those things? It was well known what those things were. Felony conviction, the consequence of that was always the loss of all goods and assets, temporal goods, confiscation of all your goods. And then generally, too, the penalty of death. But Blackstone makes out, he's kind of the dean of the laws of England. More copies of his treatise on the laws of England were sold in the United States even than in England. So the founding fathers knew about him. He says, well, yes, it's always the loss of goods. And then typically now, because he's talking in mid-1700s, typically now, death is also attached. So if you're subject to a felony, you stripped of all whatever you had, and in many cases, of course, those people had nothing, and defendants in these cases were often poor, they had nothing, and so the penalty of death. Well, let's just take this in the Constitution. Is there any felony charge in the United States that really works that way? I don't know if most of them with these different grades of felonies, and they're so many years in prison and so much in fines. Some of them have death attached to them. You find some statutes, two famous civil rights statutes, 18 U.S.C. 241, 242, violation of civil rights. If the victim dies as a result, the penalty is death. Okay. And it's 5 years in prison and such fines as may be levied. But that's not quite the definition, the constitutional definition. But in any event, here we have it. We have a lot of disabilities that have been attached to the word felony, attached to various crimes. You can't own a gun. You can't vote. You go on down the list. They're probably the two most consequential ones. I think probably in some jurisdictions you may not even be able to hold public office, being a felon, because you can't get a bond, right, as a felon. So now the question becomes, Trump is convicted. There'll be an appeal, surely. And if you're going in the D.C. Court, there'll be an appeal to the D.C. Court of Appeals, and that'll be sustained, affirmed, because that's a hanging court as far as Trump's concerned. And then it will go to the Supreme Court by years. So now the fellow has just been elected, and let's say he's convicted just after the election, and now he's going to go and be sworn in on the 20th. I think there might be a lawsuit saying, well, you can't swear this guy in because he's a convicted felon. Or there's certain things he can't do. He can't give. I mean, what are the consequences of a felony conviction in the armed forces of the United States? That's dishonorable discharge, I take it. Right? If you're a member of the armed forces and you go and you go off the base and engage in bank robbery or something, you get a federal bank robbery conviction. I think it probably is that you are drummed out of the armed forces with a dishonorable discharge. Well, can he give commands to members of the armed forces, the Pentagon, for instance, when he himself is a felon? Well, he's the President of the United States. He's manager. Yeah, but he's a felon. Well, there's some litigation that you can, how long would the opinion of the Supreme Court have to be on that one? Right? So you start thinking about this. This is a lawyer's bonanza. Especially given, I assume Trump will still have the money to pay the lawyers, the exorbitant fees that lawyers charge. But it will never end for this fellow. Because here I'm thinking of things, and I'm not a particular opponent of Trump. Right? I'm not someone looking to cause him difficulties in the courts. And I can think of these things. It's very, I'm not sitting down at night pondering this very carefully over a glass of, cognac. But there certainly are people who are doing that in Washington and New York and other places in this country where they want to get rid of him. So I can throw this stuff out sort of off the top of my head, and I'll bet if someone were to pay me in the $2,000 an hour fee that lawyers in Washington, D.C. get, I could come up with some pretty good arguments for getting rid of him on that basis. Now, they'd probably in the long run be fraudulent, but so what? What difference does that make, right? A lot of arguments that lawyers make, they're kind of on the edge. Because you're entitled to test the waters of the law. Right? Within bounds of ethics, of course, right? You can't give the court false evidence or withhold evidence or what. There are limits. But certainly the envelope of the law is very elastic. Especially as is this case with the Trump versus Anderson I just talked about. Instead of simply saying, wait a minute, the guy has never been convicted of an insurrection, and he would have to be convicted of insurrection under a federal definition of insurrection, and where would that have to be? Probably that would have to be in a federal court, but certainly we would need a federal statute. Well, we do have a federal statute dealing with insurrection. Oh, was he ever convicted under that? No, end of discussion. And he can't be convicted of that in any state because he didn't commit the federal insurrection in any state. Couldn't be convicted in a federal court in any state because he committed so-called insurrection, if he did, in the District of Columbia. That's the only place that has venue where the crime was committed. That would be like a 2-page opinion. Well, they didn't want to get into the intricacies of history and what various members of Congress said at the time that the 14th Amendment was being debated or ratified, or a little thereafter, whatever, in and out and back and forth. Pseudo-intellectual discussions, which open up all sorts of, doors or little Pandora's boxes that people can open up, and various horrors of litigation will hop out. So that's that. Now, the other topic we had kind of falls into that in the same way. It's a kind of lawfare in a different sense. Legislative lawfare.
This is Kaiser Johnson with Liberty and Finance, and these are the Miles Franklin Weekly Specials for March 11th through March 18th, 2024, while supplies last. First, we feature 90% junk silver mixed dimes and quarters at just $1.99 over spot. We also have AU pre-1933 Gold Liberty at $65 over a 1-ounce spot. And finally, we're offering our choice 1-ounce palladium bars at just $119 over spot. To order our specials or any of the many other options we have available, call us at 1-888-81-LIBERTY. That's 1-888-815-4237. We're available after hours and on weekends, and we look forward to speaking with you.